Welcome to Peace of Mind Planning with Dubs Herschlip. Dubs, would you like to introduce yourself?
Sure. Yeah. Thank you. I'm a Washington attorney with about 23 years of experience in estate planning and business, both from a transactional and from a litigation perspective. So I have somewhat of a unique perspective that I can offer in terms of what's an effective way to draft an agreement with the end result in mind. That is, how is a judge going to enforce a will or a trust or a prenup or whatever it is that we're talking about? How are these documents that we're drafting as a part of estate planning going to be effective? And that's sort of the litigation and transaction interaction. But I also have a business background, and so it's really one of my pet projects to help business owners understand transition planning as a part of their estate plan so that they can maintain the longevity of their business and perhaps the value of their legacy over time.
Wow, you're quite the generalist, Dubs.
Thanks. That's a word that people ask me not to use, so I'm
Oh no.
trying to refocus into just business and estate plan. But yeah, when I went to the University of Washington School of Law, I double course loaded and took all the courses that they offered every quarter because it was the same price, and was able to get just the various aspects of law woven into my legal education. And then as a practice, I actually went forward and carried that breadth of experience into my practice. So I hope to benefit others with that. But in terms of my future practice, I'm focusing just on estate and business planning and litigation.
Yeah, Dubs is a super smart guy, so he knows all about the intersections of all different practice areas of law.
Thanks,
Dubs,
Sarah.
could you tell us a quick definition, just so everyone knows, what does estate planning mean?
Yeah, estate planning is really a formal legal plan in the event of crisis or incapacity or death, so that your surviving family members or loved ones or charities can inherit all or part of your estate. For different people, it means different things. It can mean a will, it can mean a trust, it can mean a durable power of attorney or end of life care decisions, like in a healthcare directive. It can also mean a community property agreement or a prenup, or for some, it might be transfer on death deeds or a treasure map to things like financial assets or personal property list, or sometimes people want to leave their digital assets to others, or they want to include an ethical will so that they can explain to their loved ones what they've learned during life and what they want their loved ones to carry forward as their meaning and message.
That
So
sounds a lot more broad and detailed than I initially thought. Could you tell us why it's important to have an estate plan?
yeah, for different people, it means different things. Again, there's a long list of different documents that can be drafted to formalize someone's estate plan. But really, in general, it's important for people to have an estate plan so that they have certainty of outcomes during and after their lives. So, for example, if I was to become disabled, it would be really important that I have a financial power of attorney so that I can choose who it is that's going to manage my assets in the event of my incapacity or disability. Or end of life care, a healthcare directive is really critical in communicating to my medical providers how I want to be treated during the end stage of my life. So certainty of outcomes. Another big one for people is to avoid unnecessary legal costs. The cost of estate planning is really just a small fraction of the cost of litigation. If the uncertainty of an estate comes to court, court litigation can be tens of thousands of dollars, which is just many multiple times of what it costs for estate planning. So to avoid unnecessary costs, estate plans are really important. Also, to simplify transfers and transitions. We talked a little bit about how some people might need certain deeds to transfer real property from themselves to their heirs and devisees, but also someone has a business, then the estate plan can help plan for the transition of the business from that key person, usually the founder of the business, to someone who understands the business and is able to run it beyond the life of the founder. Other people, high net worth individuals, really want to understand how to optimize tax treatment. Parents, an estate plan is really important so that they can choose guardians to take care of their children. There's also, if someone has a permanent dependent, making sure that the gifts or the inheritance that's passed to those dependents doesn't disqualify them from public benefits. So there's a lot of different reasons to have an estate plan.
Seems like across the board that really allows people to have control in situations where they might not otherwise be able to have any control, either after they're gone or when they're sick, things like that.
That's right.
So I noticed there's a lot of younger people in the audience, basically a pretty big age range here. When should people start thinking about creating their estate plan?
People should start thinking about or creating their estate plan as soon as they have assets or people to protect. Just to choose an extreme example, even someone as young as an 18-year-old going off to college with parents who are helping them through school, they may want to start an estate plan that includes a power of attorney authorizing their parents to take care of financial matters for them, or a healthcare directive authorizing the medical providers to let their parents access their medical records or to make decisions on their behalf. So people with children definitely need to start their estate plan in order to plan for the guardians and trusts for their children. Anyone who's nearing retirement will want to talk about estate plans so that we can get things organized in a timely fashion and avoid any sort of time limits that may apply. Anyone with a business that wants that business to continue as their legacy beyond their lifetime also should urgently be considering an estate plan.
I never thought of it that way, but I do actually remember back when I was in college, I had to sign a bunch of paperwork so that my parents could find me if I got hurt. So it sounds like as younger folks, especially, probably should be thinking about this. What's the first step we should take in creating an estate plan or considering creating an estate plan?
Yeah, the first step is really to focus on someone's goals, on our goals. When we're coming about our own estate plan, we want to think about what's important to us, what our values are, what our priorities are, and more simply, who gets what. I mean, I can talk about values for quite a bit of time, but it's most simple to just think about, okay, what do I have and who's it going to. That's one of the easiest ways to understand what can seem really complicated and daunting. The sort of hot button issues that people might want to consider, this is where an attorney really comes in handy after the basic groundwork of goals and what assets and loved ones or beneficiaries we want to be thinking about. We also may want to keep an eye out for assets out of state that can really complicate someone's estate. Permanent dependents, I had mentioned earlier. It's really important that we think about them when we're doing our estate plan. Total net worth is another factor that often influences people's estate plans as they try to optimize tax treatment. People with non-US citizen spouses and heirs really should be thinking about an estate plan in order to avoid unnecessary penalties. And then people, I'm not sure what the favorite phrase is, but people with mixed marriages or children from a relationship other than the one that they're currently in also really should be looking at that for planning their estate plan. In other words, they want to think about, okay, well, if I have 3 children and my spouse has 2 children and I brought X amount of assets into the relationship and they brought Y amount of assets into the relationship, which assets are going to whose children, which assets are going to be available to the spouse or partner. So those are other details that really should be considered when putting together an estate plan.
Thanks, Debs.
Mhm.
So I feel like I remember hearing that there's some unique quirks in the law in Washington around estate plans. Things such as long-term committed relationships might have more of an impact than they would in other places. Could you tell us more about details that might be unique to Washington?
Yeah, thanks. That's That's probably my area of specialty is
Mhm.
Washington law. Committed intimate relationships really are a unique thing of Washington law that I'm not sure even Washingtonians are really aware of, but people from other states probably aren't either. And that's a multifactorial test that I'm not going to get into here, but just basically, if you live with someone in a committed intimate relationship, then that person may have claims to community like property so that they're treated much like a marriage, so that when one of those partners dies, the other partner may have an interest in the property that they shared together, and that can be really confusing to both partners and to the other statutory heirs, such as the children or the parents or the siblings of the person who's passed away. So that's one really unique detail about Washington, is that even if you're just living with someone in an intimate relationship, the courts of Washington may treat that as or very similar to a marriage, and then divide up property that you might otherwise think is yours, because the courts in Washington would consider it community-like property, meaning that it was owned together, even though one of the people might have had different plans. They might have said, for example, in their will, hey, I want all my property to go to my children. But then after passing, the children would find that really only the property that is in the estate goes to the children, and the committed intimate relationship divides the assets prior to it going into the estate. So someone could end up literally with only 25% of their assets going to their children for failure to kind of plan for that in advance. That being the committed intimate relationship, or even marriages. Most of this same advice applies to marriages, not just the committed intimate relationships. Washington also has some other unique features like transfer on death deeds, which allow, this is one of my favorite planning techniques. It allows people to transfer interest in real property on death outside of probate, just like a bank account, for example, is payable on death to the designated beneficiaries. You can use a transfer on death deed um, to transfer real estate to beneficiaries by recording it in the county where the real property is located, and just designating the beneficiaries as you want them to take it and the percentages that they'd take it. There's also personal property lists in Washington are preferred, so that we don't have to put a whole bunch of details into your will, and we can just kind of keep it general, so you can do your will one time and then maybe not have to revisit it. So it's just a one and done, because then if we use personal property lists outside the will as authorized by Washington law, you can change those personal property lists as your assets change. Not real estate or finances, but just like cars and furniture and jewelry and guns and um, whatever other personal property you might have. As that property changes, or as you decide what beneficiaries should get that property changes, then you can go ahead and change the personal property list by just making a new one and signing it and dating it in your handwriting and keeping it together with your original will. There's also in Washington um, state provided long-term care insurance. Insurance is also a very important aspect of estate planning. Even though we don't offer any insurance, we're happy to refer you to people who specialize in insurance products. And long-term care insurance is one of those critical elements for people as they're planning for their end of life. And in Washington, we actually have a general long-term care insurance fund. So you may have a benefit that you're unaware of. And I'm happy to talk to people about that if they're interested.
I think all of that sounded really like significant in its effects on what people's plan ends up being, especially that committed intimate relationships detail. Zooming out from Washington, though, are there some like really important factors that we need to consider just for anyone creating an estate plan overall?
Yeah, important factors again really begin with the who gets what. Um, when we're figuring out who's going to receive property, we want to think about, is it going to be our spouse because they get special treatment? Is it going to be our children, or third parties or charities? And then how does that relate to um, the law and tax codes? Also, are there different interests in the assets that we own? Like we were talking about community property law. I may not actually own all of the assets myself. I would I would share them with my wife, or if I had a committed intimate relationship partner, then I'd share it with them. So we got to think about how title is owned to each property, and then really, as we're going through this estate plan, a lot of the estate plan we can put words in writing, but we really want to think about, who do you trust? Are we aware of someone who is good with finances and is trustworthy? Those people in our lives are critical, and we rely on them heavily. And now is also one of those times when we're doing an estate plan, because we may want to ask them to be the holder of our power of attorney so that they can pay bills if we're disabled or incapacitated. Or if we're at the end of our life, who shares our values about end of life decisions and is aware of our own preferences? We'll want to name them in our healthcare directives. Or we may also want to ask those people who are financially savvy, to be executors of our estate, particularly if they're in Washington. It'll really help them deal with our estate assets that are in state. Trustees also, who do we know that understands the terms of long-term investing? I'm talking about diversification and rate of returns and those sort of things. We want those people to act as trustees, because they're going to be managing the assets over a longer period of time, potentially for the benefit of our children or other beneficiaries. And then really, who's going to care for our children? This isn't the financial person that we're talking about, although it could be. It's the person who has the best relationship with our children. We're going to want to name them as guardians. And are they close? Are they in state, or are they somewhere far away that we'll want to name an interim to guardian to take care of the kids immediately? Say there's, some unforeseen crisis, we'll want someone to swoop in, take care of our kids, feed them dinner until the long-term guardians are able to come, perhaps from out of country or out of state, to pick up our children and start taking care of them. So those are some of the factors that I like to think about.
It sounds like trust is really, really important, but also just expertise in general.
That's true. And we want to have a conversation with those people, after I meet with the client and we have this discussion and we identify some of the trusted people in our lives. Then we want to go out and actually have a conversation with those people to make sure that they understand that we're putting them in our estate plan, and give them the opportunity to accept that responsibility. It could be a really big responsibility, and it's also an honor to let people know that we trust them enough with all of our life's possessions and our children and that sort of thing. So they're really important conversations to have.
Yeah, I guess I thought of it as more of a one-way relationship, but it is a two-way relationship where they're also agreeing to help you. Um, that also reminds me, going back to where you were talking about who you trust to manage a specific asset of your estate plan. I was thinking of all those people and families where there's always like one person in the family, either like a kid or even like an uncle who studied computer science or something, that really knows how to fix all the technological things in your life. And I was wondering if you could tell me a little bit more about the digital estate planning and how that ties in with the types of people maybe we want to be asking to take care of certain parts of our estate plan.
Yeah, this is a really developing area of law that is still developing. I think we've got a long ways to go. But basically, your digital assets include everything that you have on your phone or your computer, from your social media accounts to credit card accounts to cryptocurrency keys. And so we want to think about, and I guess I shouldn't leave out the photos, the treasured family photos, right, that are
The most
somewhere in our
important.
photo library. Yeah, the most important asset of all. It also could include intellectual property. I think that is often left out of these conversations. But when we invent something, or when we write a book, or even those same photos, we may be taking amazing photos of orca whales, breaching, and those have value. And so that intellectual property is another piece of digital asset that we want to make sure that we're certain where those assets are going and who has access to them. Is there some sort of barrier to their access? So really, that's where we start talking about password protection and the terms of service for each of those accounts. Social media accounts are going to differ from credit card accounts, for example. And what among those accounts is going to make it difficult for your loved ones or your trusted advisors to access those accounts when you're no longer able to help them or manage them in accessing those accounts. So we really want to start organizing the digital assets first with kind of an inventory of what we have, and that's going to start out with the email accounts, right? I don't know if I know anyone without an email account these days. So, we start with the email accounts and whatever ways that we access our bills, if we're doing online banking, et cetera, and whatever digital services we're using, we're going to want to make sure that we put those on an inventory with, user IDs, usernames, passwords, and whatever other credentials are required to access. Sometimes there's two-factor identification or authentication. There may be additional verification questions that we'll want them to have answers to. So when we're doing that inventory, we're going to want to think about social media accounts, subscription services accounts, online banking accounts, credit card accounts, utilities, and then even contact lists. This is something that's overlooked even by estate planners, because we're usually thinking of things of dollar value. But as someone's planning for a funeral, the contact lists are critical. So how does the person perhaps access our cell phone, right, to get access to the contact lists so that they can send out invites to the celebration of life? Shopping accounts too. We may want to, see if there's an outstanding balance or close them. Again, photo and video sharing and storage accounts. These are often really important, and we don't want to avoid, or we would like to avoid them being deleted. So again, we want to identify sometimes where they are. They may not actually be online. They may be in some external hard drive. So we want to identify where they are for people and how to access them. Again, access to smartphones and tablets and stuff. What passwords or pins are required to open them, other digital collections, or if someone has a business and they maintain websites or blogs or online marketplace stores and domain names, how do we get our key personnel to get access to those things so that our business doesn't fail during our greatest time of need? Another one, and this is really the one that's developing most rapidly, is the cryptocurrency keys. Some people have incredible amounts of value stored in cryptocurrency, but they're notoriously and by design difficult for other people to access. So we really want to come up with a foolproof plan for transferring cryptocurrency keys to our heirs. And then, we have the other potential intellectual property in the form of texts or photos or graphics or audio files. Maybe someone's a musician. Again, we just want to identify all those assets, the location, and how to access them. And that's kind of the digital estate planning in terms of inventory. But once we've got just the asset identification, then we want to talk about wishes. How do we want these assets to be transferred and to be used? Do we want them to be deleted, or do we want them to be continually operated, like in a business with a website or online store? And then who's going to be able to best do that? Is it going to be the executor, or is there a trustee, or perhaps someone who can replace us in our business that knows how the business works, that knows how to use the assets to the benefit of the business to maintain the stability and perhaps the revenue that your family depends on from your business? And then even, long after you've passed, how is this stuff going to be stored? The digital assets may be the easiest to store and preserve for future generations. And what is the online platform that's best suited for each person and their heirs? So for some, it might be a filing cabinet, a fireproof locked safe. And for others, it might be cloud storage. So we just kind of want to talk about all of that and what suits their needs and their beneficiaries' needs.
Yeah, I can imagine that if somebody had all of their data stored in the cloud and then nobody had their password to like log in and keep the payments going for whatever cloud storage they had, then things might get lost.
That's right.
Right. Yeah.
So in planning, we can try to avoid that.
I can see how that's super, super important. I know that I've read several stories through the years of people whose loved one passes away and they go to the social media site with their request to access the account, but the social media site ends up just shutting down the account because, oh, the person's dead. No one can get in. Um, so even just having the password somewhere where other people can access them is really important.
That's right. And for intellectual property, also identifying the asset so that the heirs can continue to protect the asset and it doesn't just get infringed upon and they don't even know that they have ownership of that asset.
Right. At DBL, we do a ton of intellectual property law, and one of the main things is you have to defend your rights. Otherwise, you can lose them.
And
So,
that's again where some of the crossover from estate and business planning comes in. Is it might be best for the family to put it into a family trust or an LLC so that the business can continue to collect royalties on intellectual property and stuff. So yeah, there are a lot of options, some of them better than others for the beneficiaries, and that's why we want to plan now to make sure that nothing's lost, none of the value's lost for our heirs.
so going into the options that people have for doing that type of planning, what's the difference between a will and a trust?
Yeah, this is perhaps a whole year-long conversation for law school, but to keep it simple, a will really transfers title later on your death or during probate, and a living trust transfers title now, so you can take care of a lot of the planning and transfer issues for your heirs, so that they don't have to worry about it later. Um, there's also a whole bunch to say about tax planning that we don't really have time to go into today, and really it's a particular conversation for each person. But the big difference is a will transfers title on your death, and a living trust allows you to transfer title now and kind of solve some of those transfer or transition problems for your heirs, so they won't have to deal with it later.
Interesting. Okay, so the will transfers the title later, and the trust transfers the title now.
Well, the probate transfers title later. You have a
Okay.
will, and then you go to court with the will and you submit the will to the court, and then the court reads the will, and then they say, okay, well, this is the
Mhm.
executor who is named in the will. That person's going to be in charge of the estate. And then depending on whether the probate is with or without intervention, court intervention, the executor may go around and transfer title themselves if they don't have, if it's without court intervention in the will. But if it's with court intervention, then they need court orders for transferring a lot of the titles. So a will really just postpones transfer of titles to the probate, and then a living trust, when it's formed, needs to be funded by the grantor or the funder. Say you're setting up a living trust for your spouse or for your children. You'd need to put assets into that living trust now yourself, so that the trust is funded for the beneficiaries later. So part of the process that I would do is, as someone's attorney, I'd form the living trust, but then I'd also help them fund the living trust so that there are assets in the trust, and the trust can do what it's supposed to do: take care of your spouse, take care of your children, what have you.
Awesome, that makes sense. Um, so out of all the different types of people out there, would you say, like, after hearing this webinar, should go and start creating their estate plan as soon as possible?
Well, definitely the people we've talked about, anyone with people they care to protect. So that's a very broad category, and it really could be people and charities. But people with families, anyone with young children, they definitely want to have their estate plans done ASAP, to name guardians in their wills and potentially trusts for the benefit of those children. Anyone with blended families, again, that's if you have children from outside of your current relationship, even if those children aren't minors, the relationship itself can cut off some of the inheritance unless there's actual written agreements in place explaining, what's community property, what's separate property, what am I entitled to leave to my heirs, and then, you know, putting that all in writing, either in the will or in the trust, so that the children of a married person can make sure that their children are inheriting as intended, and it doesn't necessarily go all to their second or their their subsequent spouse or partner. Business owners also, I really think that all business owners who have a business that could outlive them should be doing an estate plan now and thinking about how to transition or how to plan from them, either through retirement. This is another aspect that business owners may want to plan for their own retirement and develop a transition plan that involves, a buyout with some sort of insurance offering, or perhaps key personnel insurance to pay their replacements so that the company isn't at a loss during this transition period, and spending revenue on hiring your replacement when a lot of founders aren't taking a whole lot of money and it's more their passion project. Well, their replacement is going to want to be paid, and so sometimes there's insurance products out there who can help afford the new CEO's salary. um, People who have borrowed for student loans also should be looking at estate plans, because if we put together a prenup, for example, we can use that prenup both as a shield and a sword, so that if someone has debts that they took for student loans prior to the marriage, we can protect their spouse from those prior debts so that they're not debts that go against the community property. Um, anyway, there's a whole bunch of different things we can do for student loan borrowers. There's also charitable givers. It's really one of the best things you can do for charities is to name a charity as a beneficiary in your estate plan, and if the estate plan doesn't really lay that out with specificity, then estates may end up going to the state instead of the charity of your choice. And then people concerned about their end of life decisions, and the quality of their care is really something that's important to estate planning. And then finally, people who want to just leave a legacy, whatever it may be, can do so through their estate plans, and really should start now um, to get that in writing.
It sounds like basically it's any type of person who would like to advocate for themselves throughout the end of their lives and also for their family or their loved ones after they pass. Could you elaborate a little bit on some of those categories? Specifically, I believe you said the blended families, um, student loan borrowers. I was as a student loan borrower myself, I'm interested in that one specifically. Any of the other more complicated ones?
hmm Yeah, so blended families, I that's my word. I'm not sure if that's the commonly understood term, but again, it's just if someone has had children from outside their current relationship, whether it's a marriage or a registered domestic partner, or if they have a committed intimate relationship where they're living with someone and pooling resources. Anyone that has children from another relationship really needs, at least in Washington, really needs to look at an estate plan and putting documents together so that whatever they intend to go to their children actually happens. One fallacy is that people believe that they can have a verbal agreement with their significant other and say, "Oh yeah, all my stuff's going to my kids, all your stuff's going to your kids," and that couldn't be further from the truth. Because if I were to say I want all my stuff to go to my kids, and then I passed away and there was litigation, none of my kids could introduce the statement that I want my stuff to go to my kids, because it violates the dead man statute and is not admissible as evidence. So it's a just a super critical mistake to not actually put together an estate plan when someone has a blended family, because there's no other enforceable way of executing or of carrying out my estate plan other than following these formal estate planning procedures, because the rules of evidence and really some of the rules of human nature end up really frustrating what our intent is if we haven't followed the formalities of a will or a trust or a prenup. Those documents are essential in order for my wishes to be carried out. Otherwise, I'm just kind of leaving it up to chance for how the assets get distributed, and chance, unfortunately, is not just in the abstract. It's also affected by the greed and the desperation and the misunderstanding of other people who survived me. So if we want to avoid conflict between our loved ones after our passing, conflict over their inheritance, this is a really important way to avoid that conflict, is to just put it in writing, get that uh, you know, confirmed in writing for everyone else to rely on moving in the future, and not just assuming that people are going to honor what it is that I said. Um, there's more to say there. That's blended families. Moving on to the other one that I think is really important is business owners. A lot of us who start our own businesses, it's a passion project, it's our life's work, and it's very important. Sometimes it generates IP, maybe it just generates revenue that sustains our family and pays for our lifestyles, right? All of those businesses require someone to keep it going. And if I'm not going to be around, I need to have my replacement. And replacements don't just grow on trees, and nor is everyone really capable of doing the same thing as someone else. So I want to find or identify the person who's best suited to take over, to who can I open the door for so that they can come in as soon as I'm leaving, whether it's through retirement or passing away, and maintain the continuity of the business, maintain the revenue for the benefit of our families, um, or maintain a legacy. Maybe we've done something completely amazing and we want that amazing to continue into the future, through inventions or maybe creations of art or industry. All of those businesses need transition planning, and most all of the transition planning is going to happen through estate planning and not necessarily through another context. So business owners are super critical. And then student loan borrowers, again, when we're talking about liabilities, usually my debts are only payable by my estate. And so it's a little bit confusing to kind of mix this up in estate planning. One thing that happens in estate planning, though, is we draft prenups or community property agreements, or really agreements between spouses about what's shared and what's separate. And if I'm able to draft that document and call a student loan separate, the separate property of someone prior to marriage or even after they've been married, that asset then cannot be collected against my community assets, because those are two different things. Me as a separate person, Dubs, me as a member of a marital community, so that I can actually protect my marital community from my pre-existing student loans that I took out before my marriage. If I put that stuff in writing and and make that plan. There are other aspects in terms of loan forgiveness and stuff that can come up in estate plans, but that's really the critical one, is just protecting spouses and marital communities against prior separate debts.
I actually have a personal question about that. So for the unmarried student loan borrowers, is there a way for their estate plan to protect co-signers of their loans, such as parents or other individuals?
Well, Kara, since you're not in Washington, I can't advise you on your matter,
Right,
but
right.
that's a good
I know
question
there's
for
a lot
your.
of us out there.
Mhm. Yep, that's so this is just general advice, and when if we were talking about personal guarantees, that's the liability of another person, so it would be up to their estate plan in order to protect themselves or their loved ones from their own liabilities. If you've had, or if someone's signed as a personal guarantor on a loan, that's their liability to be dealt with in their estate plan, and then the person who's the principal borrower also has a liability to deal with there. So you'd have divergent liabilities on the same debt, and each party would have to take care of their own potential liabilities in protecting their family and loved ones from them.
So if that was something they wanted to take care of for their family, say they don't want it to get passed on to their co-signer, that's something that could be included.
No, with the cosigner would have at that time accepted the liability, and it wouldn't have been a an otherwise transferred liability. It's a liability that they accepted at the time of signing the personal guarantee or the co-signing.
Thanks. Okay, that clears things up.
Mhm.
So Going off of that, before we go into the Q&A, I know we're getting close to the hard stop at 1 o'clock, but it sounds like there's different concerns at different stages of life, and there's certain conditions that can sort of trigger a new consideration that might not have existed before. What are some of the changes in someone's life that would trigger them to need to like reevaluate their estate plan?
That's a really interesting question. In the documents, we can often plan for many, many contingencies. So if we can imagine some future event and how it would change our plan, we can usually put those into the plan. We can plan for contingencies. We can say if someone turns 25, or if someone dies, or if someone inherits $1 million, or if someone becomes addicted to drugs, or if someone gets a divorce, we can plan for just about any future contingency that we can identify. But if you already have a plan in writing, and you're wondering, oh, well, do I need to revisit my plan or revise my plan? Most of the plans drafted, or at least that I draft, and ones that I see other attorneys draft, are usually one and done, and they're intended to last for all time until you pass. But others don't. And in those situations, if you have a divorce, that's a really critical time to revisit your estate plan. Or if some of the people named in your estate plan pass away, beneficiaries, executors, trustees, holders of powers of attorney, or healthcare delegations of authority, when those trusted people pass away or are no longer trusted, that's a time to revisit the estate plan, because we may want to change who it is that we're giving authority. For example, in our power of attorney, we don't want to just give anyone authority over our finances while we're disabled. We want to make sure that we have an active, trusting relationship with them. And if that changes, then we'll want to go back and revise that power of attorney, because it really does give someone tremendous power over our assets and our well-being.
Thanks, Debs.
Mhm.
I think so. I've been keeping you all to myself, but I think it's probably time to open up the Q&A to everyone who's been waiting patiently. Does anyone have a question for Debs? I don't see anyone unmuting. Oh, thanks.
If you do like an intentionally defective grantor trust, does that do any like creditor protection?
That's a great question, and very particular. It depends on the state. Different states have different creditor protection laws about trusts. There was a long period of time where trusts were a primary resource for asset protection. And then in the 80s all the way through the present day, trusts have been disfavored, so that trusts generally do not offer much as far as asset protection, except for spendthrift trusts and special needs trusts, which have very, very limited um, rules. And we can go, if you contact me, we can go through the particulars of your situation. But simply transferring an asset into, an intentionally defective grantor trust, for example, um, because it's a trust that I am likely the grantor, and, possibly directly related to or closely related to the beneficiary, it might be my spouse, then courts can disregard the trust. Specifically, if I'm all three, if I'm the grantor, trustee, and beneficiary, Washington courts are going to disregard that trust for the benefit of creditors all the time. And so trusts are no longer the favored mechanism in Washington for asset protection. Change over time. And there are some exceptions, particularly with special needs trusts that have spendthrift clauses, and really limit the distributions, so that there aren't regular predictable distributions for creditors to attach. I hope I'm making sense.
So it's more of just a tax play than anything. It's not really going to do any degree, especially if you're the grantor, trustee, and beneficiary, right?
Right. If you're the grantor, trustee, and beneficiary, then a trust is going to offer you little to no asset protection, and there are better techniques in Washington for protecting assets.
What would be something that's better?
Multi-owned corporation or LLC would be one example. Multi-layered approaches such as legacy trusts with management companies and holding companies separating the assets. I prefer to separate the limited liability entities to insulate each asset or revenue producing asset so that if one gets sued, then it's compartmentalized from all the others. And if I get sued, I'm not the sole owner of the asset. So simply suing me doesn't give you full access to the asset. I hope that makes sense.
So like, could that be accomplished by just like splitting different assets or revenue streams into different disregarded entities, for example, like single member LLCs?
That's kind of the opposite of what I'm saying. I think this is probably a
Okay.
little more complicated that needs like a particular conversation to talk about.
Okay.
Splitting assets could be interesting, but the single owner LLC is in particular is problematic due to a couple cases that came out in Washington. I think they were solely federal cases interpreting Washington law, so they're not necessarily controlling, but there were a couple federal judges who questioned the asset protection value of a single owned LLC.
Okay.
Any other questions? Oh, I see you raising your hand, Julie. Oh, I can't hear you. It doesn't say you're muted through Teams, so it's possible that your microphone's not picking up.
Or you could type it into the chat. I don't think I'm.
Yeah, feel free to type it in the chat. Also, after this webinar, I will be sending out a thank you to everyone who signed up, including the YouTube link, and also some contact information for Dubs so you can reach out to him. So if you have future questions after this ends, you can go there.
Thanks, Karen.
I see Julie typing.
Mm-hmm.
Does anyone else have a question in the meantime? Oh, it just came through.
Holographic wills, are they still valid? That is an interesting question, and I am looking it up right now because I'm not sure if there was a development recently, and I didn't look at that recently. But yeah, so generally, Washington law does not allow for holographic wills, and I'm not sure if there was a recent development on that. And I'm just kind of scrolling through to see yeah, so yeah, not that I'm aware of. I don't know if there was a recent development that you're referring to, Julie, but generally in Washington, in order for a will to be valid, and this is really I guess I'm not supposed to comment on the laws of other states, but this has been true for over 1,000 years, is that wills require two witnesses. Getting them notarized is really a best practice, and I can kind of explain that a little bit. But if someone drafts a will and doesn't have two witnesses, then it's not a will. If you are doing an estate plan and the person has two witnesses, it may be a valid will, but it's really best practice to also get it notarized so that those witnesses to the will aren't called into court in order to admit that will into court. So then we have what's called a self-proving affidavit that ends up being notarized by by the notary, so that the witnesses sign saying, yep, I observe this person, they're of sound mind, etc. in signing the document. But yeah, oral wills and other, just napkin wills, etc. Are not valid unless it's in writing, signed by the decedent or testator, and witnessed by two people.
Can I ask another question?
Sure.
Do you know why people are using the credit shelter trust in Washington?
The credit shelter trust in general is a spousal technique in order to, it's almost hard to believe, but when there is an estate tax threshold and the person is married, then there's a spousal credit shelter trust option that can be used so that if my spouse is inheriting, and let's say, they're inheriting over the Washington state tax threshold, so well over the 2,147,000, but they're inheriting way over that, I can then have in my will the option for my surviving spouse to disclaim the inheritance over the estate tax threshold. So like the first dollar and every dollar above that estate tax threshold into a trust for their benefit that they're the trustee of and that they can give themselves money from for their needs as defined by the trust. That is a spousal credit shelter trust optimizing the tax treatment where the estate tax of Washington would otherwise be applied. And then if there are two different estate tax thresholds, so I described the Washington estate tax threshold, there's also a federal estate tax threshold that's quite dynamic and is going to really sunset in 2026, but right now is just an extraordinary amount that most people aren't worried about. But when it comes back down, people do worry about the federal estate tax threshold. You can also do a qualified terminable interest trust that then allows for the second set of inheritance that exceeds not just the Washington estate tax threshold, but the federal estate tax threshold into a trust for the benefit of my spouse during their lifetime. And then after that, it ends up going to usually to the children, and that's when the estate tax is applied.
So it's like if you're gonna give your wife $5 million when you die, you could have 2 million go and get taxed, which will be the exclusion, and then the remaining 3 will go to the credit shelter trust to avoid the Washington tax.
That's right.
It's literally as simple as that.
That's it.
Yeah. And then,
Well, I
then
mean,
that
it's actually, there's a little bit more practically, they have to actually elect that treatment. They have to tell the taxing authority, hey, I'm doing
right,
this.
right.
There's this trust. So there are a couple practical steps, but yeah, that's the idea.
Okay, and then that trust, then how does the money ultimately get to the wife? Is it like an income? Are they like an income beneficiary with the kids as like a remainder beneficiary? Or
Depends on the terms of the trust. And
okay,
it's usually not that specified. It's usually for the IRS mesh, maintenance, education, support, and health.
okay,
So that's, I mean, that's pretty much the most vague that it can be. And I prefer vague because I can't predict the future. I can't know when that person's going to need it. And in defining specific amounts of income, unless it's, a specific kind of trust like a slat where the income should be defined, I generally prefer not to define the income so that it's not predictable by creditors.
okay,
If a creditor knows you're going to get paid $5,000 every month, they're going to attach your bank account when that $5,000 lands. Does that make sense? So I prefer not to define the distribution rate in the trust, and generally, and again, we're just speaking generally, just leave the spouse as trustee so that they get to determine when do they get the money. They could leave it in there for the benefit of their children for the remainder of their lifetimes, or they could pay it out if they need it for housing or whatever.
okay.
I briefly saw Robert writing in the chat. Do you have a question? Would you like to ask that? Otherwise, I think we need to wrap it up. All right, well, I will be sending out Dubs's contact
I'm
information,
seeing
so if you
Robert
have
typing.
more questions, oh, I think that was someone else. If you have any more questions, I'll share his contact information with you, as well as his bio page on our website and the recording of this webinar. So hopefully that helps. Thank you for coming.
Thank you very much, Carrie. I appreciate your help. This was great. Good job.
Yeah. Big thanks, Dubs, for all of the good advice and information.
Thank you. See you later.